Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Welcome to the Jury Thinks What, a podcast by trial lawyers for trial lawyers. I am Saul Gruber, your host from Gruber Trial Consulting, and today is an interesting guest. It's someone who I've known peripherally for many years. He is also a nursing home lawyer. His name is Ed Dudensing from Sacramento, California, and Ed is a trial stud. That's right, trial stud. He has the largest nursing home verdict in Sacramento County of $29.1 million. He has the largest assisted living facility verdict in Sacramento County of $42.5 million. He's got multiple eight-figure nursing home verdicts, and he does it his own way. You're going to listen. You're going to hear him talk to you about one of the first things he looks at in a nursing home. He says he splits it between three things: the medicine, he looks at the staffing, and he looks at the corporate value. Now, who's doing that? Just fascinating stuff. And he takes us, he's going to give you his thought process up and including to trial. And it's going to be different than a lot of the other people you talk to, different than a lot of the ways our listeners approach these cases or any case. And it just works for Ed. And it's just a treat to listen to another way to do this. So I think you're really going to enjoy Ed Dudensing. And we are here for this segment of The Jury Thinks What, is a person who I've met a couple times, I've talked on the phone with, but I have never actually sat down and really broken down and tried to find out his way of thinking. But it's Ed Dudensing out of Sacramento, California, does nothing but nursing home cases. Am I right, Ed?
That's correct.
Well, Ed, it's good to meet you finally, face to face, sort of face to face. I don't think we've met before, have we?
I'm not sure. I think we've been at some joint conferences together many years ago, but hard to say at this point.
I know we've talked on the phone, but
yeah, right.
Ed is, for those of you who don't know him, it's the only reason you don't know him is because you're not keeping up with what's going on nationally with verdicts, because Ed's verdicts will blow your mind. I mean, I'm on your webpage now, and I'm looking at just two verdicts that I see right here. Is you've got the largest elder abuse verdict against a SNF or a nursing home in Sacramento for $21.1 million, and then you have the largest assisted living facility verdict in Sacramento of $42.5 million. That's not bad, Ed.
Well, thanks. I mean, I think recently, January 24th, 2023, which is not on the website yet. We had a $30.9 million verdict, skilled nursing facility verdict. So we're really proud of that one as well. We're in post-trial proceedings on that one, and so we've had some big ones. And we're proud of them, and we think that we've had to work hard to get them.
I don't doubt that. And I definitely want to talk to you. That's really what I want to talk to you about. I mean, everybody all over the country is trying for 7-figure verdicts. And it sounds like for you guys, 7-figure verdicts are nice, but it's really the 8-figure verdicts you're looking for, maybe a 9-figure verdict that coming next year.
Yeah, I mean, the punitive damages are such an interesting part of these cases, and we've having gone through this now, three $25+ million verdicts, you start to understand what it's like, what you need to get that done. And that's a pretty, having, it's just like anything. The first time you drop into it, which for us was in 2010, you're like, oh my, I wasn't planning on this. I didn't, but then the second time and then the third time you start to say, okay, I know that you're thinking about appellate issues. You're thinking about optics in front of a jury. And so you do get a little more granular each time in terms of what succeeds, what's good, for in terms of appellate review and so forth.
So the first thing that blows my mind, has always blown my mind, and you and I have talked about it in the past, you're a cap state for pain and suffering.
Right. Yes. I should say that as of January, for cases filed January 1st, 2022 and later, there are no pre-death, there's no caps to pre-death pain and suffering. Now, it's interesting because, and not to get too granular, but there's a carve out of that change in the law relating to the Elder Abuse Act. And so there are still arguments being made that we may still be capped for our elder abuse causes of action. But for a car accident and everything else, we've now followed the other 45 states that don't have pre-death pain and suffering starting January 1st, 2022. And arguably as well, I mean, in the case we just finished trying, there was a carve out for cases where preference had been granted. So, but yes, that is in play for us. When it comes to punitive damages, it's the unremitted amount. So we are still arguing for the unremitted amount, which is kind of an awkward and difficult if they make a $4 million award and they're thinking about that when they're going back to punitive damages. We know it's going to be cut down to $250,000, but we need to argue for that number because the unremitted amount is important for the the reasonable relationship test of State Farm.
So although there's some cap depending on the type of nursing home case it is and how it's brought, your punitives are based on the unremitted verdict. So even though there's a cap, it doesn't matter if it's a $10 million compensatory verdict.
Yes. But it's tough because, this is, again, the law, I don't know if we want to get real granular with a change in the law, but it's tough to be arguing for a big, and if you, for example, if you look at wrongful death and pre-death pain and suffering, wrongful death in our state and potentially elsewhere, it cannot be used for the denominator in the reasonable relationship test. So, but wrongful death is hard cash. So, you're out there trying to argue, well, like, you really should be making a big award on the pre-death pain and suffering, even though that's going to be reduced because the multiplier is there for the punitives.
And that's where it gets crazy for me, because in a case where there's a cap, I would think quite often, certainly if they see your name on the other side, they're going to offer pretty close to the cap, if not the cap, early on to get, like, so you're turning down the cap amount.
Yes. Well, we have, the enhanced remedies,
I mean, think about this for a minute. And I had this conversation with Leslie Clement, who I know is one of your neighbors out there. You guys actually turned down in theory, the most you could get in pain and suffering.
Yes, but one of the enhanced remedies also is the fees. So there's two buckets. There's attorney's fees plus the $250,000 pre-death pain and suffering, plus wrongful death, which we would argue is uncapped as well. So those are three buckets, and then punitive damages. So, But yeah, I mean, I see your point is still there, which is, and of course we hear that from the defense a lot. That's the cap, and this is a micro case. And
I'm doing a lot of cases, a lot of consulting with a lot of people in cap states. And I more than understand they're having a difficult time. And in most of those cap states, the punitives are capped much different than they are in California. And they don't have the fee shifting that they have in your elder abuse statute. But they're saying to me, okay, I have a cap of $750. They're at $450 now. It's tough I could probably get $500. How do I go to trial over $250,000?
Yeah.
It's tough.
Yeah, no, I think that, we of course, we've been dealing with the MICRA, with the statute as it relates to professional negligence, which hasn't raised the pain and suffering above $250,000 until just this year.
Wow.
Since the 70s. And, those kinds of policy decisions have implications in terms
Sure they do.
What types of, litigation there's going to be and what types of responsibility and accountability there's going to be. Those those are policy decisions, but that's pretty tough for
Yeah.
who are victims of simple medical malpractice, which I don't do, but
Right. So let's break the cases down. So let's talk about when the case first comes to you. I mean, if your ultimate goal is probably, when you look at a case, to see what can you do for them if you have to try the case. That first few weeks when you're talking to the client, what are you looking for in order to take the case?
Yeah, I mean, I think one of the things that where my practice has evolved is we understand that punitive damages are going to be limited by law to 10% of the net worth of the enterprise. So in the old days, I would take cases where it was, there were 2 or 3 facilities, or even a single facility, standalone facility. I don't do that anymore.
Okay.
I'd like to have the largest impact I can, and of course, that's also leverage toward settlement and so forth. So one of the things we look at, we do corporate valuation of the corporate enterprise before we take the case, and that's a significant dividing line for me.
Wow. How do you go about doing that?
Well, I mean, usually, we're blessed to have an industry that does have a lot of public reporting,
Right.
both federal and the state cost reports. You can divine fairly easily, and you have things like the Levin and Associates valuations, acquisition reports, where they do valuations by bed, assisted living, and skilled nursing bed, and so you can do back of the envelope valuations just
Right.
by number of beds. And usually, I mean, the corporate, there is some limitation to the universe. So we run into the same, of course, but it's usually not too much of a task. We have an economic expert, and we do that. That's a very important part of our intake process.
Wow. And it's funny because everybody else I would be interviewing would be talking to me about damages. They'd be talking to me about pressure wounds, understaffing. Interesting. You go right to the economic worth of the defendant.
Yes, that is. I mean, obviously, we have a geriatrician. We don't take any case without the geriatrician saying it's a case. Sure. But I think that is something that I always try to talk to people about, is to consider that issue. I mean, if you consider the fact that you have a standalone facility and the value of that facility is $5 million, let's say that
Right.
You've got $500,000 cap on punitive damages just by operation of law. This is not a cap, but it's just so versus a $30 million or a $50 million limitation. Those are multipliers that make a big difference.
So we know one of the first things you're looking at is the defendant and their value for the reasons you just told us. What about from either a medical point of view or a staffing point of view? What do you look at anything that way in the beginning of looking at the case?
Yeah, we run this. We have someone who does a staffing analysis, and then of course we have a geriatrician expert who makes, or we use essentially usually the same geriatrician expert, but sometimes others, and they look at the medical side of the case, and all of those need to align, basically. I mean,
Yeah.
People take and some of these verdicts that we've gotten, all of them have had their challenges in one form or another. But I mean, like if you have, there's the medical case. I feel like if I were apportioning my mind around a case, I would be looking basically a third at the finances, a third at the it factor, which is something other than the medicine. And that could be understaffing, that could be, the cover up, that could be, there's case, even in the early parts of the case, you generally have, some cases are sexier than others for
Sure.
some reason. And then you have, the basic medicine on the ground, the neglect. And I kind of put them into those 3 buckets. And if everything aligns, then, we'll take it. And, the plaintiffs, of course, matter too. And I always meet with the plaintiffs after all that's kind of fleshed out, to make sure I feel comfortable with them. But that's kind of the way I look at it.
So I kind of get what you're talking about from the business valuation point of view. You can look at cost reports, some SEC filings, some other things that you're probably a member of, so it doesn't really cost to do it.
Yeah.
And obviously the medicine we get. I mean, anybody who does nursing home knows that's over here. We're going to put that over here. That can't be the big thing. How do you go about evaluating staffing at that point?
Yeah, so I mean, it's interesting. Staffing is an evolving it's an evolving topic, especially CMS expected, is a methodology that is used. And when I say CMS expected, I'm referring to the fact that there, especially in I guess in the California is where Charlene Harrington and others started with the idea that the reimbursement under the prospective payment system, there is a methodology in terms of time studies that were done to look at how long it takes to provide care, and that's been reduced into numbers through the RUG scores and through so there is a CMS expected methodology.
So I mean, it used to be when CMS had that on their webpage, it was gold. Right. I mean, we couldn't get Charlene Harrington, who, if you're new to nursing home and new to the podcast, she is one of those published authors that really give us everything we could possibly want, plus when it comes to staffing in a nursing home and how it's the key to everything. And your expert should have everything she has as almost the Bible. Is that fair?
Well, and I would add to that by saying that when PDPM came along, which is the current methodology is, she wrote, along with several other authors, an important peer-reviewed article that defined a methodology that could still essentially draft off of the PPS method, and still use a CMS expected. And so I think that's a very important article because
it's got to be an important article, because my belief is and was, I'd have to see if federal courts would even allow that, is once CMS kind of cut that off and no longer use the RUG scores,
right?
Expected staffing. I mean, can it even? I mean, you think it's still a viable base to use in a staffing case?
It's interesting. We had for example, the case I just finished. They had disclosed two experts on CMS expected, debunking CMS expected.
Right.
That CMS expected was never meant to be. They had David Otway, who was one of the people that was involved in the first study, and then John Bobles, who was also talking in those areas. And my feeling about it is that when you're going to attack staffing, it needs to be multifaceted. Every time. So, we had kind of I could say list sort of maybe the 5 or 6 things that we looked at where I really like comparative metrics, and you can do a lot with those in the state and federal, where you can compare percentiles or, where they fall in terms of, for example, it's a comparison between acuity and staffing. So in our case, for example, we had 50% more acuity and RN nursing was 2% more. So one of the things I like about comparative metrics are that they are simple and easy to understand for a jury.
And I can tell you, as someone who does, I'm probably doing now 5 to 10 focus groups just on nursing home cases, not counting the other stuff, a month. That's all the focus groups want to know. You could throw numbers at them all day. First of all, they don't understand them. Secondly, all they want to know is, well, how does that compare to either A, what the normal nursing home in the area does, or B, how does that compare to, like you're talking about, the acuity inside?
Right.
They're dying for that. So if anybody's listening to this, they're dying for that.
Yeah, it's real simple to put those together. You just have to make sure that you have someone who can pull to, it's the databases. You could there's the federal cost reports if you want to go obviously you can look at how the metrics look, state cost reports, federal cost reports, or at least in California we have state cost reports as well. Right. And there's a wealth of information there, and it's really accessible, and it's accessible by design. I can definitely say that about the state cost reports right there in the statute. They are made accessible so that consumers via other avenues can access it and compare and understand it a little bit better. So it makes a lot of intuitive sense. And so that's always a great thing. And, so just kind of listing some of the others, we of course had former employees testifying. You have the family members. It was kind of interesting in this, we had received a lot of emails. And so we had, things like Yelp reviews, going to notice.
Right.
And then also we had one witness that we kind of dredged up from a Yelp review who was extremely powerful. And then you have what we call markers. So we were allowed to get into things like fall rate, even though it was a pressure sore case, because we had a staffing expert who was like, these are the things you would expect to see with understaffing: high fall rate, a high pressure sore rate. And so, of course, this is going to be judge specific, but I like to refer to that markers thing because I think that is something that, that you can use as an indication of understaffing as well. And so I feel like whenever you're trying to prove an understaffing case, do not put all your eggs in one basket. Try to find multiple ways to get to the same conclusion,
Well, what I love about what you just said is we could do a week-long podcast just on what you just said.
Right.
Just breaking it down. I mean, I agree. There's got to be formers, I think, in any real punitive case. Because the formers, to have somebody up there saying something like, we never had enough people, and we were always running around, we were trying to get people in there, it tells the jury everything they need, everything they think.
Right. Yeah. I mean, it's really is good. And I think I would just say, like, my closing argument, my PowerPoint, I drafted the whole PowerPoint. It was 470 slides. It was 5 hours and 75 slides on understaffing, just attacking it from many different angles. We had emails, we had, summaries of what formers talked about. We had, we had CMS expected was slipped in there at the end, because you do get, I mean, like, what I really like about taking a multifaceted approach to proving a managing agent,
right,
is that you have jurors that run the gamut in terms of what is persuasive to them. And you do have wonky jurors, who kind of like that. And it adds a veneer of wonkiness to, like, this has got to be true. It's got a level of professionalism to it.
Yeah.
So I like throwing a lot of different things and talking about how they all lead to the same conclusion. And we're doing that in a number of different areas, but understaffing is one of them.
All right. So let's stick with the understaffing for a minute, because I think that's one of the trickiest things that nursing home lawyers do is the staffing issues. Because, when we, and I think I may even predate you, when we were first starting to do these, right, in the late 80s, early 90s, I mean, we would get these cost reports. We had to learn how to read them.
Right.
And, we weren't relying on anybody telling us or having any cute software. I mean, we just read them and figured it out what it meant. It had like 10 different charts up. Now it's a little bit easier for us. And for us in New Jersey, the state cost reports were incredible. That's since changed. I didn't even care about the federal cost reports, quite frankly. It was the state ones gave me everything I needed. That ultimately changed, and then people started to really attach themselves to the rug rates and the expected staffing, and I kind of think that's gone a little. So now it's in that first 6 months, you're looking at the case. Are you pulling the cost reports at that point?
Oh yeah, we pulled the cost reports before we sign up the case, because the cost reports. So our state cost reports are still very good, have a lot of information. So we will, I think that. I mean, and this may be, I guess it depends, but from my perspective, before I sign up the case, I have the back of the envelope valuation of the corporate agency. I have a staffing metrics report, and I have the geriatrician's feedback on the case. So I have all of those things before I sign up the case. A lot of times I might understand the staffing of a corporation, because I've dealt with them before, but I do think it's important to have a general understanding of what the staffing picture is going to look like. And sometimes we get, we get the whole gamut. I mean, sometimes we'll get like where they're way over state averages, and you're like, okay, I got to understand more about this.
Right.
But, the phrase that I like to use when you're dealing with a lot of these nursing homes and acuity is basically mini hospital. I just call them mini. They're basically running a mini hospital in there, but they're staffing like a nursing home.
Right.
I think mini hospital conjures up in people's minds what, a certain level of staffing because they've all been in hospitals. Most people have been in hospitals and they see nurses and they see doctors. So if you start calling a nursing home a mini hospital, I feel like if the acuity supports that push.
Right. That type of argument must really work in an assisted living facility, where when you and I started, they were like little apartments, and now they're literally mini hospitals.
Yeah.
When you get to the 5th level of care, and it's crazy.
Right. I feel like I always bring up like anybody who's ever had a child and been in the last 10 years, it's changed. It used to be stay there and relax for a few days, and now it's like, and you can it all rolls downhill. So,
Right.
The higher acuity patients that used to be in hospitals or in nursing homes, the nursing home patients are now in assisted living facilities, and the acuity in some of these beautiful looking assisted living facilities is through the roof. And you've got one nurse maybe who's, just
half an aide for the whole place at night.
Yeah.
It's crazy.
Yeah. Yeah.
So getting back to the metrics. So, and this is what everybody wants to know. I'm telling you right now. Everybody I talk to, and I talk to way too many people. I know we laughed before we came on that you said you're not a great marketer, and I said, yeah, well, your verdicts market for you. But I, on the other hand, I'm talking to the world. I feel like every day.
Yeah.
And everyone's going to ask me. I loved what Ed had to say, but what's his metrics based on? Like, what documents is it based on? So we know we've got the cost reports. I assume, are you also downloading the information from the 5-star?
Yeah, you have the payroll-based journal,
right.
That is considered to be, potentially more reliable. And when you start to talk about metrics, you're going to need something that is universal, either statewide or federal. And so it's typically those two, cost reports and payroll-based journal. The 5-star potentially as well. I feel that the 5-star is kind of a one-way ratchet for us because, for example, in this case, they were a 5-star facility, so we moved to exclude it. We moved to exclude it as lacking in foundation and hearsay, and because this is their self-reporting,
right?
And there's some verification, but this is their self-reporting, right? So the court granted that, excluded the 5-star. However, I think in the reverse situation where we were seeking to admit it, what is the getting over hearsay objection is easier because those are party admissions. And then you still have foundation. You're going to run into foundation arguments, and it's a question of how well the foundation could be laid and whether it should be laid. But I do think similar to other situations, we do get kind of a one-way ratchet on that because when they self-report things, we can use it because
right.
it is over hearsay objections because they're party admissions, but they can't because they can't admit party admissions. So those are the basics. And
so are you downloading? I guess your office just downloads all the PBJs for the area, just so you have them.
We have a third party who does it.
Okay.
So he'll just look at. He'll immediately do the OSPOD staffing.
Right.
So that's our California cost reports. He'll look at, let's say, there are probably 150 comparative metrics in there, literally.
Sure.
There's many. And we've kind of honed them down to about 30 that we look at. So for example, supplies per patient day, food. We're just looking at because like, for example, if the average food per patient day is, $6, $6, and, in this facility, it's $2, that's a piss off
right.
factor. Turnover, so we look at, maybe 15 or 20 metrics, just back of the envelope. Again, we're just looking to see, we were looking at their acuity, what percentage Medicare, what percentage managed care, and then we start to look at their staffing. And so, when we see a number that is, let's say, equals the average in terms of nursing hours per patient day, and we see acuity that's twice the average, that's an easy picture to tell. It's just a matter of how finding the words, not getting all, this is why I say things like mini hospital, not getting all locked into just be simple about it. These people are really sick. Come on, if you've ever seen your parent in ICU, there's one nurse for every patient or two patients because those people have to be tended to. When they come from a hospital, they're still, if they're post-surgical or if they've had a fracture and they've had they still need, that have those needs. And so to staff like a long-term patient who's wandering around, that, I think it's a little bit of this is not psyching yourself out in terms of how you're talking about staffing. Just keep it simple. And the metrics can be kept very simple. You know?
I think that's the key. I mean, the hardest part I think that we as lawyers have isn't getting the information. It's distilling it and then repeating it to someone so it's understandable.
Right.
Because if you don't have that ability, and you're going to start throwing cost reports, and you're going to use phrases like expected staffing and acuity, and you're not going to give them simpler words, no one's going to follow it. They're just not following that.
And like, for example, CMS expected, which I agree is a more of a challenge, but I do think the reason I've always liked it is that I do think that it resonates in the sense that, you know, this is what they're getting paid for.
Exactly.
I mean, like, I just feel like people understand that very, very simply. You know, you don't go to you get a car wash, you pay $20, you know, and, you know, they charge you for a wax, but you don't get the, you know, like the upcharge in services, you need to get reimbursed. You're getting paid for it, but then you're not provided. I mean, come on, you know, like that's, it has the tax.
And what I will always love to do, rather than rely on the numbers, and I'm curious what you think about this, we would always just ask the nurse, you know, what's your normal day like? How long does it take you to do this? How long does it take you to do that? And really get them talking about how hard it is. And
it's funny because I that kind of was certainly was what I learned on, you know, back in the early days.
Right.
And, you know, like even running the whole litany with CNAs of, you know, having them list their jobs and how long it takes and all that kind of stuff. And I've gotten away from it. It feels like a little bit of like a lawyer trick to me, you know, like, I don't know.
That's interesting.
And it also, to me, has a little bit of a feel, you know, it's a little bit drawn out, and you get into,
it's definitely drawn out.
Yeah. And then, you know, like, let's just say, for example, and this, we've certainly had this happen where you get them saying that identifying their tasks and how long it takes. And it's, you know, once you add everything up, it's, you know, it's 2.5 times the amount of time they spend there. I wonder sometimes whether, you know, it does put some meat on the bones when you're, like, for example, if you're dealing with formers and they're just saying there wasn't enough time. Right. That's kind of a, you know, like, there is that sense that people, if you polled the workplace, you know, what percentage of people would say that they feel rushed at work? I mean, you know, like,
well, isn't that the defense in every case? I mean, that's the defense says. Everybody says we don't have enough time.
Right. And I think you are speaking to sort of difficult, you know, abstractions in terms of what is going to be persuasive in trying to prove understaffing. Because I've always felt that there is a bit of a it's subject to a jury just saying, well, I mean, you know, is that normal? Which is why I think kind of the metrics, or just sometimes when you can get the lucky, you know, former employees that have worked at different places and are willing to draw the comparisons, because comparisons matter, I think, you know, for a jury.
I think comparisons are the key.
Yeah.
You know, I mean, to stand up in front of a jury and talk about hours per patient day. I mean, you're just going to have 12 people like bleary-eyed, glass-eyed looking at you. Hours per patient day. And then you start to explain it to them. I don't know how you're doing it, but my experience has not been wonderful with that.
Well, especially because the numbers are a little 4.1 versus 4. You know, like they seem kind of small. I mean, they're not, right. You know, but I do think, I mean, I can't remember how many times I used the word outlier and this was talking about profits over patient care. But it's kind of the same thing there too, where you're talking, you know, you do need to say this is not normal.
You have to,
especially when you get into punitive damages. They need to feel like this is something that where this company is an outlier. They're not normal. They've gone beyond. And I think it's the same thing with understaffing. You know, yes, there are going to be complaints. Every facility is going to have that, but you know, there's that, and then there's what's not normal. You know, which is the next level.
You know, I've told lawyers all over the place, I would love, they don't even need me to do this focus group. They could just, you know, get 10 people at the gas station and say, I want to explain a concept to you step by step. Tell me what you think you're hearing from me, and let them listen and then repeat it back to you in a normal parlance. You know, instead of HPPD or out, you know, it's incredible the great stuff you get back.
Yeah. Right.
So you're now armed with the good family. You're armed with that it factor, right? That I always called either a horrific event or just a horrible, horrible injury, you know, or a cover up, which is sadly almost in every case, it seems like anymore.
Yeah. Right.
now you've got to decide, you've got your reports. Now you have to decide to file a lawsuit. Are you back in California? Are you fact pleading or notice pleading?
Fact.
Okay. So it's like federal court. So your complaints are 150 pages.
Not that long, but we have to plead with particularity the elder abuse. So we just go ahead and put it out there.
How do you figure out who you're going to sue?
Yeah, I mean, part of the corporate analysis, our economic expert, we try to do our best sweep with that. Understanding that if we're talking about that issue going up the corporate chain, we try to do our best in trying to understand. We've obviously got the OSHPODs that might identify things. You've got, our economic expert can do that type of research, and we do that research because I do think that's important. Inevitably, we're going to get it, 3/4 of the way right, and I always take the same approach with that, because we'll get contacted by them saying, this person is the wrong person. I just say, look, as you know, as soon as the discovery hold lifts, we propound discovery, and one of the things we always do is the PMQs regarding organizational structure of the corporate entities we've named. And I just say, I'm not going to release anyone. I don't care about your letters. Just give me the PMQ of someone who's going to say things under oath, and then but one thing I do think is important that it seems to be not the case in sometimes when I get brought into cases, is to do the corporate, at least the PMQ reorganizational structure, to have that be in the first wave of discovery that's propounded. Don't wait, because you need to know. I mean, yes, you can do some of the, like, for example, going for financial data and things like that. You can back end that a little bit, but you can't you shouldn't back end identifying who the proper entities are. And it's really not that hard. You just have to, you do your own research, and then you just depose people. But, and usually for a PMQ regarding organizational structure of a corporate entity, you will get someone who knows. And
PMQ, let me just stop you.
Oh, sorry.
What does that mean?
Okay, yes.
I think I know, but I'm assuming, in fact, I do know.
Yeah. I think that PMK was the person most knowledgeable,
right?
And that changed about 15 years ago in California, and it's called the person most qualified.
That's what I thought it meant.
Yeah, the requirement being that they produced someone, the person that they consider to be most qualified on certain topic areas, and the topic areas that we'll identify are, including affiliated entities, and and so I think over the course of doing those depositions, which of course every time you notice a deposition is going to take 6 months, no matter what, but at least it's not. You don't want to be. I feel like what happens a lot is from other practitioners that I have seen when I pick up cases, is that they think that the corporate case should, the development of that should go after.
Right.
And then, and I don't necessarily disagree with some of the difficult aspects of the corporate case in terms of, like I said, getting financials and things like that. But in terms of identifying the corporate parties, I think it is really important to do that very early, so you don't start to run into problems with.
In a way, what I tell everybody all over the country is when you're listening to this, think your own corporate designee deposition rule, and who you and remember, you're making the defendant pick the person who's going to testify, not you. So when they come in and they say, I didn't do anything to figure out who's who, I don't know these companies, I don't think you're going to get sanctions just because judges never sanction anybody. It's got to be pretty nasty, but it sets you up for discovery. And I also look
start that process.
Yeah, I also look at the cost reports on the related entities too.
Right. You might get a little bit there. It's funny. In the last trial, we made a very big deal about the fact that they were required to identify everyone who had a 5% direct or indirect ownership interest, and they just didn't identify any of the, they just completely shined it on. But it ended up being a very significant, in terms of what we're talking about, as far as this corporate entity over here is, they're reaping all the benefits. They don't even disclose themselves publicly. They're behind. It ended up being something that we made some hay of. But yeah, that's one source. And your economic experts should be able to get plenty, just if they're used to doing this type of stuff. But it's always part of the first report. We have evaluation and identifying potential corporate, and then followed by the PMQ, the person most qualified type notice early, and staying kind of on top of it. It's really, I would just say, it's really not that hard, as long as you just have to kind of continue on, because the first PMQ may not be the right one, and this and that. But if you just stay with that while you're doing the case on the ground, You'll get there, within a year, and then you'll be happy that you have the right entities.
Yeah. And not only that, I mean, they don't want to give you anything when they receive the whatever request you're giving. You really have to keep on it. And what they say is everything. I don't know how you feel, is never even close to everything.
Oh yeah.
It just isn't.
Yeah.
You said something interesting. You said you were talking about waves of discovery. Tell me what you meant by that.
Well, I mean, it's what the low hanging fruit to me. I mean, and maybe this is how everyone operates, is we have a discovery hold, which is we can't serve discovery for 20 days after service, which gives them the opportunity, if they wanted, potentially to serve beforehand. But at that time, we serve a bunch of stuff, and so that's kind of the first wave, which is, we serve probably 40 deposition notice of percipient witnesses. So we will cull through the chart and get whatever we can in terms of percipients.
Right.
On the ground. We'll go up the management chain, and if we don't know the DON or the administrator, then we'll just identify them by job title. We'll go to the supervisor, and then we can usually pull down the corporate, and we'll go ahead and notice them by name, and then we'll do a bunch of PMQ, and we do all of our document, kind of like Kozerski, we do all of our document stuff through PMQ notices as well, because
I'm going to ask you about that.
Yeah.
I did that religiously when I practiced.
Yeah.
I just did, because I want someone there to tell me what it is, where it is, and why it's not hard to give it to me. That's always been my belief.
Get so much more.
Oh.
And I also think it's a great, it's early in the case, and it tends to be a great time to get things like, the DON saying, I have no involvement in the budget,
Right.
because they're not focused on it at that time. So it's a wonderful time to get some pretty good testimony before they're all keyed up to be talking about how, corporate doesn't dictate the budget or things like that.
Right.
But also, I mean, what we've kind of moved to a hybrid where we also propound RFPDs, because of the fact that we really like the supplemental feature of that, so that later we can ask them to update, whereas
Right.
you don't really have that with depositions. So, but it's actually pretty easy, because we propound them both, and they're like, well, this is the same thing. We say, of course, you're not going to do it twice, but we want the PMQ. We're going to definitely get that testimony. We want people under oath authenticating.
So you don't think it's enough just to attach the RFPs to the debt notice? You do that, and then you serve them as well.
Yes, because of the, I don't know what it's like across the country, but most jurisdictions, I assume, have the ability to serve a supplemental, and the supplement, the benefit of a supplemental interrogatory, so in California, you have two chances to do that later in the litigation, saying, for everything we've previously propounded, give us your latest information. And it's the same thing with documents. So RFPDs, you can do a supplemental RFPD right at the end of the case and say, for everything we propounded, give us your documents. And the reason it becomes important is because at trial, if they try to introduce new documents or witnesses, we can say, we not only did we propound the original RFPD, but we asked, whereas with the PMQs, you can't do that. And so you might be 3 years later, you've resolved all the PMQ stuff, but you can't ask for those documents again through that vehicle in California. And so we do it both ways now, just to kind of cover it.
Interesting. Listen, I can remember in the mid 90s, before any of us, except Wilkes and McHugh probably, were so attuned to all this, we'd be at trial and they'd be giving us charts and records in the middle of trial. So didn't we ask for this? Well, yeah, but they couldn't find it. They didn't know it was there. And judge says, you have it now. What's the difference? Like, I don't know. We're in the middle of trial. And I guess I want to go back just and revisit just the waves. I've always believed in, I've called them tiers, where I would absolutely, one of the first things I would do, like you said, is make sure you have the right corporations, but I probably wouldn't get into the budget and who had control going up that chain, the VPs, and things of that, until the second tier, because the judges would just get mad at me and say, you haven't even proven your case yet. How do you feel about that?
Yeah, no, I absolutely agree with you. There is the law on apex witnesses. I think that, to me, the way I prefer to do it is that I will notice everyone that I think all the way up to the top people. And then we start to get into the next thing, which is scheduling, right? And so we will work, they'll say like, you're not entitled to these, say, okay, we'll agree that we will, hold off on this. But the reason I like to do that is because later in time, if one of the things that's always helpful is to have a point in time where these things have been noticed. So when it's 3.5 years later, these were first noticed 3.5 years ago. We agreed to wait in meet and confer process until this, because they said that we didn't need these witnesses. So I like making that those trails, and we rarely get, I just haven't, in order for them to bring like an apex motion, they're seeking to depose this person,
right?
They meet and confer, and we always, if they meet and if they really want to focus on that issue early, and they meet and confer, we say sure, we'll hold off. But we put our flag in the stand.
Okay, that's interesting. You're not taking 40 deps in every case, though, are you?
If we don't settle it early, I mean, we do take a lot of depots. I mean, Zoom is fantastic, needless to say.
Now, when you're taking deps, though, you go in with a plane. You're not taking 4 or 5 hour deps of everybody, I would think.
Oh, no. We try, like for the CNAs, I would say an hour.
Okay.
Hour and 15 minutes. The nurses, typical nurse, 2 hours. And that's also staffing, comes as,
right.
We have associates typically doing those, but I will get involved too, depending on, what it is. But so I try to be pretty targeted. I mean, I feel like one of the things about depositions for me, yes, I know the cross-examination piece, as far as, the video, and we use a lot of video in our trials. But the thing that I want to know and see is, who is this person? What are they going to be like as a witness? Do they remember my, like some of the,
sure.
I'm always like, make sure you get their back. I like to get the whole background. Who is this person? Because I just want to understand that. And then, do they remember my plaintiff, and are they credible? Just, those are kind of like the basics. And so you can run through those depositions pretty quickly.
Now, here's something that I've seen lately. I've always taken those depositions. I've always treated depositions as getting sound bites for trial. It's rare that I'm really seeking information about what happened. We know what happened. And I'm looking for names. I'm either looking for a reason for additional discovery or a soundbite for trial. So I would tend to ask questions like, well, you would agree that blah, 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 and get the yes or the no. In the last few focus groups we've been doing, they've called that lawyer tricks. And now I'm rethinking that maybe I want the witness to say it in their own words, that it will hold a lot more water. What do you think about that?
Yeah, I mean, I think it's a great point, because and I was a prosecutor before I started doing elder abuse, so I've done a lot of trials, and I think one of the mistakes that less experienced attorneys make is they're leading. Even in cross, I think you have to think about times when you can be less leading if you feel that the whole conventional wisdom from long ago, where you would where you're not you lead in cross-examination because you don't want dangerous testimony. You got to remember, I mean, jurors are really just intuitive and smart, and they feel like you're just if you're pushing words down there, it's definitely a balance. You got to think about who you are up against. Like if you're looking at like Dr. Locatell is a very strong witness on cross-examination. She's really, really effective. I wouldn't get in the cage with her. I would lead her with like 5 questions and then just sit down and hope for the best for the rest of. But I think that when you're talking about someone who has maybe limited language skills or just limited life skills, and you're out there, Mr. Experienced Attorney, you've got to be really careful about those optics. And those optics include how you're asking questions. Are you being fair?
Yeah, they really do. I mean,
they should look at it. I don't even bother. It's like, you don't have to be nervous. Just say like, of course you're always wanting to set a standard of care. Right. But that's usually pretty easy. You just say, what are the main interventions for preventing pressure ulcers on the heels? They'll come right out with it.
They really will. And
So you really need to think about whether you really want to lead, because I know from my own experience that is much less effective than having them say things in their own words.
Yeah, and anybody who's listening to this, I want you to start thinking about that in every deposition you do. You walk away thinking you've got great testimony, but you really don't. You have great questions that they said yes or no to, and a lot of jurors will not give that any credence at all. They think you're playing a trick, and I've been called out on that. I've been called a bully once at trial. I said, "You're just a bully." I said, "Okay, I'm not a bully," but
well, another
yeah.
practical point on that, I think, is you can ask. Sometimes what we'll do is, like, if we're a little nervous about how it might turn out, is you can ask a leading question such as, "Do you agree that it's important to fully and accurately chart?" Yes, and then why?
Yeah.
So you give them a chance to talk.
Exactly.
And some of them will go with it. Some of them will, but like sometimes when I get leading answers to leading questions that I'm feeling pretty good about the witness, then I'll circle back and ask it in a non-leading way,
right,
to get them to expound on it.
But that question you ask it at depositions, I love that why question.
Yeah,
I just don't think you can get a bad answer. You just can't.
Even when they, like, if you talk about do you agree it's important to prevent pressure ulcers, and you say why, if they can't give an explanation, that's pretty good too. I mean, like,
exactly,
you're not really worried about it. It's like, and I think that fits for a lot of things where you just see people leading, and I see this with the defense all the time. They're leading witnesses, even than their own witnesses, through like, I don't even, like with their experts or something. I don't even, you can probably do that anyway, but I wouldn't even bother to object, because it just reduces the effectiveness of it so much.
I try not to object at all at trial. And we're going to talk about that in a couple of minutes, your trial strategies. But yeah, every time I stand up and object, all the jury is thinking, ooh, what doesn't he want me to hear?
Right.
But my favorite why question still is when you've got the staffing person or the DON on there, and they say, well, here's our staffing ratio. Well, you could have one more nurse if you wanted to, right? I mean, if somebody chose to have one, there's nothing to stop that. So why don't you do it?
I like that.
Same thing with aides. If one more would help. Well, they can't write everything down. Why not? Because then they won't be.
Those are good.
Yeah, because then they're not giving care. Well, okay, so then one more person would help who's writing down. Now we could document everything and care.
Yeah.
And they look at you like you're an idiot, first of all, and they may be right. I may be an idiot. It wouldn't be the first person to call me that, but it's just what everybody else is going to ask.
Yeah.
Right. It's and you just say why, and I'm telling you, every time it says, well, because we're not allowed, because corporate won't let us. I mean, it goes right there.
Yeah, that's really nice. I like that.
So you have 40 depositions, you have 700 hours with your experts in the case. You're into the case for, I don't know what, 150 grand before you're even thinking of trial. If you're listening to this, his facial expression said, "You wish it was 150 grand." Now you're getting ready to try the case, right? You've done the depositions, you've got the formers. What's the first thing you do when you're sitting down with your team and you're saying, all right, we've got a trial in 3 months? What do you do?
Yeah, I mean, it's we have our own protocols.
Sure.
And so, and those do start, probably 3 months out, but what percentage of those cases resolve, but still, I mean, we've got a series of things to do. What I always tell young lawyers is, that, you need witnesses, witnesses and exhibits. And this comes from my old prosecutor days. When we would prosecute these small cases and stuff, the things you'd be focused on first and foremost, before you're getting into the esoteric legal issues, is where are our witnesses? Are they corralled? Do we have control of the witnesses? So I use my second chair is the witness guru, and he's the witness. He spends so much time with these witnesses, and I don't mean in prepping them. I mean in just having them be so that on the day in question, they will arrive and be on time, because, for them, this is, and especially if you're dealing with formers, this is very low on their priority list.
Right.
So I think corralling witnesses and knowing who your witnesses are, creating a witness list, creating timing and order of those witnesses is a big thing. And then you, of course, have the same with exhibits, and exhibits are a monstrosity in these cases.
They really are.
And then motions in limine, we do sweeps through through all of our cases and make sure that because motions in limine can be really tricky, because the basic ones are fine, but the bespoke ones, okay, this showed up in a deposition somewhere, or you get some sense from the questioning of the defense that they're going to go in this direction. Those are a little, if you've had a lot of depositions and a lot of time has passed, sweeping through to get the bespoke ones can be difficult. And I do like to try and do that, because it's important to,
because I'm telling you, the defense is doing it.
Yeah, I mean, depending on their skill.
It seems to me anymore, I don't know how it is out in California, that the defense is trying their whole case through motions in limine now.
We take we usually file more than them. So
oh wow.
I guess I'm an outlier. I mean, I started my career as a clerk for a federal judge for 2 years, and so I like writing, and I also like. I feel that a lot of times the judges that we are trying a case in front of have not ever tried an elder abuse case before. Right. I think the standard. I mean, these trials don't happen very often, and so when you talk about concepts about understaffing and it's an education process. I'll never forget the first big trial we did, and the first thing the judge said out of the box is like, "We're only going to be talking about understaffing right. to your client. That's all that matters in this," and so there's, I think there's a fair bit of education that has to be done. And I prefer to do it before we get to a jury. So
let's talk about that. How do you do that? I agree with you.
Through the motions in limine.
Got it.
And so I can, like, a lot of times we get the same motions, denied every time, but we're educating, we're making progress, and we're talking about, like, for example, we have the Sanchez case that I don't know if there is a federal equivalent, but it relates to the use of the interposing of hearsay, the presentation of hearsay through experts.
Okay.
So there was a huge sea change that happened in California about 10 to 15 years ago, where experts are not allowed to bring up, let's say, diagnoses of the plaintiff unless those have been established by
right.
So that's a big change that and the defense, of course, the defense playbook is that. So anyway, we have conversations about that doctrine. We have conversations about staffing. Staffing is something that it's very important to us anyway, that the judge feel that if you can show systemic understaffing, that matters, and that I'm going to allow that. Right. And same thing with profits over patient care, because when you think about profits over patient care, which is such it was really the trial we just completed. I think it was really fascinating because we really I really felt the most I had in any trial, the power of that concept. And when I say that, I mean the difference between a jury feeling that a nursing home is making a reasonable profit, but not more than a reasonable profit, but they're just kind of dunderheads. They didn't, they didn't staff the way they should have.
Right.
They're trying to, versus a choice. And again, when you're talking about punitive damages, you're making a choice to, squeeze every last penny. Where you have that evidence, it's just different. I mean, it should be different. And so, I mean, I think
one is a scheme, is the way I've always argued. Like, the one is, it's a scheme that they put together, as opposed to, like you said, they're just incompetent.
And is it, I mean, but the thing is, the question I have is, aren't there a lot of industries where it's okay to try and maximize every penny of profit? And if so, what makes this different? And is it ever okay in this industry, given that you can do it in the, insurance industry or this industry or that industry? I mean, I think that there are some important philosophical questions. And there's also this whole issue beneath that, which is how prejudicial is it when you're exposing significant financial data about companies? And obviously there are limitations in every state in the union
Sure.
on that topic. So Eliminate, I think, is a great time to start broaching those issues, because I always feel that if if a trial court is squeezed in trial, it just increases the volatility of it might go in any direction. Same thing with staffing. They might, whereas if you just kind of pound away at it, you talk about, you have motions eliminated that are talking about methodologies and things like that. And the trial court starts to get deeper and starts to look at the case law regarding staffing and its relevance. Same thing with profits over patient care. How far do we go? And thinking about those things, I think it always tends toward expanding the evidence. And so I'm a fan of using motions in limine to educate and to try and expand the evidence as best possible.
One of the problems I see happening with motions in limine, both plaintiffs and defense, is, they're due a week before the trial. Mm-hmm. And the defense and a lot of times the plaintiff are dropping 50 motions in limine on the trial judge 5 days before he or she is supposed to pick a jury. Next thing you know, that case is adjourned because the judge is like, I can't read all these in the period of time I gave you to try the case. How do you deal with that? Do you just arbitrarily say, I'm going to give it to you early?
No, I'm in favor of that delay because in this environment, as long as, we try and keep parameters on it, so, I suggest to the judge, I say, I think a briefing schedule of, depending on, of course, the local rules and what's right. happened. But, we're talking about a case that we think is going to be 30 days with a jury. I think that it's important to iron this stuff out to, so 2 to 3 weeks to allow the court to consider. I try not to, I like to rush the case, I don't want delay in general, but I feel like delay in this time period works to our benefit because we have the burden. We've got to get the witness. I feel like it's so much harder for a plaintiff. We put on a case that lasted, 30 plus days, court days of in front of a jury, 70 something days. This last trial was 79 calendar days. We went through Christmas and,
how
was it allowed or how did
just the general how?
Well, it's funny because we had a jury of 12 and we had 4 alternates. We didn't lose a single juror. This was through Thanksgiving, Christmas, COVID. COVID was still really.
Oh, good Lord.
Yeah. And it was, but again, this is the way we approach all the trials, that we're trying to project that this is an important matter. And length of trial, of course, it always depends on what are you producing during that time?
Yeah.
We went we would, like in my closing, I said, we went 18 days of presentation of our evidence, not a single gap in the evidence ever at any time. So look, there wasn't an hour where, judge, this witness didn't show up. We used video, plugged in video, because we're not going to waste your time. Yes, it's a long trial. It's an important trial, and it's a trial that involves private equity. It's a trial that involves a $1 billion operator, the largest nursing home chain in California. And so we have to put on this evidence. We're not gonna short you, put you in the jury room, and have you say, well, geez, we wish we had learned about this and that. We can't do that to you. But at the same time, not wasting their time is a totally different topic, and so we're very, very focused on that at the same time.
I mean, the common opinion is the longer the trial, the worse it is for the plaintiff.
Yeah, I know that. I know that is said. None of our trials have gone, none of these 29 million, 42 million, and 31 million, none of them have lasted under 20 court days. I think, but it's a lot on us, but, I think that, we try to present, for example, we have charts of CNAs and stuff. We try to present all the CNAs, either by video, I feel like you put on 2 or 3. I mean, I think it can be done, and I've been interested and actually intrigued in possibly trying like a rocket docket kind of trial. I just think that you're dealing with a lot of people with a lot of different thoughts in that jury room. And I guess it goes back to my prosecutor background. When they have doubts, they put it on the plaintiff. Like we have the burden. We got to prove these things by clear and convincing evidence. We're talking about proving reckless, malicious, big burdens in California. And so we try to put on evidence that addresses those things.
Because, that's interesting. And it's obviously it's not wrong. I mean, I'm looking at your verdicts. Anybody who says it's wrong, what are we really doing?
Well, that's one of the things I think are great about podcasts is just you can hear different, totally different
Yeah.
approach to it and just be like, that just blows my mind. Like what kind of idiot would go, for, 20 court days. And I know from listening to your podcast and also just from hearing other conventional wisdom that getting in and out is, has been.
So, I mean, we go to the point where we're looking at what facts we want to put before them, right? Who's going to put those facts and or evidence before the jury? I mean, we're all doing that. I'm not even going to ask about that. Of course we do that. And then we'll say, well, I could put 9 CNAs on to say the same thing, but why not just put 3 and save a day? What I'm hearing from you is you've got to prove your case by clear and convincing in the California elder abuse statute to get the fees, right?
And for punitive damages, clear and convincing.
Yeah. So you're thinking I've got to do it all so that they walk away almost beyond a reasonable doubt.
Yeah, well, I mean, but I also think that it's really what are we presenting in terms of these these 9 CNAs? I really, and try not to be repetitive. I need to give them, I want a jury to see them for 10 minutes to just see who they are. Okay. Just to understand. Okay. So if you're going to have a lack of supervision, I want you to understand who these people are that you're not supervising.
Okay.
Right. So we're not on, we're automatons just going in there, and you agree that you need to, we mix it up. We do things, we try and find little different things that we want to focus on. And we try to make it, because we are very, very aware of keeping the jury, and keeping their interest. And so usually we move thematically in each week. We have something different that is kind of our global thought for the week. And, so we keep it moving, but I also think that getting some touches so we can look up at the board and say, because we have them initial, like especially if it's a shorter residency, we just have them initial where they provided care. So the jury can look at it and say, look, I've heard from everyone. There is nothing else, but yet do it in a way that is efficient. And I will run. And this is, I think, an old DA thing too, which is, I think that a lot of people feel like if they put a witness on, they need to, a lot of throat clearing. I'll put witnesses on for 15 minutes and that's what I've allocated for them. 20 minutes, so we can run through, we ran through.
So you're putting witnesses on to just go through the important parts of what they did. And then that's allowing you to connect dots between that and understaffing or whatever your theme is.
Yeah. And also care, so if you're talking about failures in care that happen across, typically we're talking about how pervasive it is, we will try to think tactically about what is different. So we're not run 3 witnesses saying the same thing. So maybe we'll go, like if the case involves failure to care plan, but also failure to, the failures of the interdisciplinary team, we might focus, we move around the focus so that it doesn't feel like I'm just hearing the same thing over and over. And I do think that's really important to kind of have that in your head, and also just not to run long and just keep, going through the same, like it looks like a script, just
exactly
keep it going. You got to keep it interesting. But I also think it's fair for them because, and we do, for example, we do an organizational chart with their photos. So we try and get that even into evidence if we can. So the jury can always like picture, like they can see, like the faces and they say, oh yeah, I remember that one. And so I just feel like it has that feeling of inevitability that you can build by presenting the witnesses that you can present. And for example, if there's, let's say that, like this last one was a 2-week residency and there was someone who a CNA who didn't care for the, who cared for the resident maybe 5 times, but they're not available. We will elicit, we'll put on our investigator and say, yeah, she said she had cancer and she would, just to say
so you're explaining to them why she's not there. Wow.
Yeah. Wow. Just so that, I mean, I have no doubt that 3 or 4 jurors need to hear from 3 CNAs and 2 nurses to draw their conclusions. I have less of a doubt as you start to look at other jurors and, and then they start to say, where is this person? We don't know about this person. And start asking questions. And that's how you end up with hung juries. And that's how you end up with saying, well, there just wasn't enough proof and your burden was high. And, you're talking about reckless, malicious conduct and you give us 1/3 of the witnesses,
And let's face it, you're asking for a lot of money. And I don't care what you think your standard of proof is or your burden of proof is, it's higher than you think it is to get that much money from a juror.
Absolutely. I mean, it's interesting with the big punitives damages awards, like what is our tactic, and I would just say humility. So that's the first thing. We always know we're going in there. We got to strike against us. We're going to be asking for a lot of money. Thoroughness, and that includes the witnesses and trying to do everything you can. Being, courteous to their time and not wasting their time, both in terms of not having gaps in the evidence and also being efficient with the witnesses. Those are some of the things that we're trying to channel, which is
right.
We're just conduits. We're not out there bragging, flashy, the way we dress and everything. And we just, and I think part of that the whole completeness picture is that, that we gave our heart and soul to giving them everything we could so that they didn't feel like, they were being put in a situation without being armed with everything that happened and everything that, but I agree with you in the sense that I do think the devil's in the detail there. That line can quickly turn into something like, oh my gosh, do we have to hear this one? So that's where it's the trial instincts and just kind of knowing where you are with your jury, and maybe we can skip this one. And, sometimes we'll skip witnesses, but, we put on 91, there were 91 witnesses in the last trial. And I think we did a fairly good job of, handling it.
Well, Ed, I mean, the proof's in the pudding, brother. When forgetting about what anybody thinks, your verdicts speak for themselves. Certainly, as someone who's pretty active in the nursing home community of lawyers nationwide, we all know your verdict. I mean, there's never a question about that. I don't want to take any more of your time. Thank you so much, Ed. This was great.
Sure.
I'd love to have you on maybe next season to talk about openings and closings. We just don't have enough time today, but
yeah, absolutely. I'm such a fan of the interactive process, and especially, things like podcasts and stuff are just really good, because I think I love listening to them and just kind of hearing other people's perspectives is awesome. And you did a great job. It's really good obviously this isn't your first rodeo. You can, just the questions and the way you phrase them is great.
Well, thank you, Ed. I appreciate it.
Sure.
And we really appreciate it. Thanks a lot.
Okay. Talk to you later.
I hope you enjoyed Ed's way of looking at things, because although it may be a little bit different, it really is awesome and has had just beyond awesome results. One of the things I talked to Ed about after the podcast had ended was how long are his openings and his closings. And he said the opening where they just got, I think, a $30+ million verdict in January, his opening alone was almost 5 hours. Again, different than what we're seeing, but boy, effective can be. Ed Dudensing, just a trial stud, like I said earlier, and just so enjoyable to listen to. Again, this is Saul Gruber from Gruber Trial Consulting. I'm your host for The Jury Thinks What, a podcast by trial lawyers for trial lawyers. And Ed said, feel free to contact him at his email, at his webpage, dudensinglaw.com, and he will help anybody who calls. Thank you for listening. I look forward to seeing you the next time.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.